Brad Pitt and Angelina Jolie are still fighting over a French winery, and the plot involves a Russian oligarch. Drake filed legal papers claiming Spotify actually artificially inflated Kendrick Lamar's diss track streams. Marilyn Manson's abuse lawsuits are quietly moving through the courts while everyone's attention moved elsewhere. And the DOJ is trying to break up Ticketmaster, partially thanks to Taylor Swift's fans melting down their website. I'm Jasmine Weg, and today we're doing something different. No breaking news, no fresh scandals, just the legal cases that fell out of the headlines but are still very much alive in the courtrooms. And they're way more interesting than you remember. Let's get into it. Welcome back to Exhibit A List. Quick reminder, follow me and find me on Instagram at JasmineWegESQ. Follow the podcast at Exhibit A List Pod and TikTok at Jazz the Lawyer. Here's the thing about the legal system. It moves insanely slowly. A case that dominated headlines for 2 weeks and disappears could still be chugging along through discovery, depositions, motion practice. We just stop paying attention because there's always something newer, shinier, and more dramatic. So today we're catching everybody up on the celebrity legal messes that are still happening while you are busy watching whatever new chaos dropped this week. Starting with the messiest divorce asset fight in Hollywood history. Brad Pitt and Angelina Jolie have been legally separated since 2016, which is almost 9 years. They filed their divorce in 2019, and yet they are still in court fighting over a winery in the south of France. And it's not a fight about custody, spousal support, or anything you would typically expect, but a winery, which is probably a big business endeavor for them. So here's the setup. Back when they were together and life was good, Brad and Angelina bought Chateau Miraval. That's a gorgeous estate in Provence where they got married in 2014. They went into business together producing rosé, which actually became quite successful, like genuinely good wine that people seem to have wanted to buy. The deal was structured so that they each owned half. Brad ran the business side, Angelina was more of a silent partner, and everything seemed fine until it very much wasn't. Fast forward to their split. They're working out custody, assets, all the normal divorce stuff. And at some point, Brad claims that they had a verbal agreement, which should get your red flags up, that neither of them would sell their share of the winery without the other's consent. That is standard business partnership stuff, but it's rare that in a sophisticated business you would have that only as a verbal agreement, but not unheard of. According to Angelina, she never saw things that way. In 2021, she sold half of Chateau Miraval to, I'm going to butcher the wine company's name, but it's a French company, by Yuri Shefler, a Russian oligarch. And she did this without telling Brad. Brad's legal team immediately fired back, saying that she violated their agreement and that the sale was designed to hurt him financially and strip him of control over something that he built. His lawsuit argues that she sold it out of spite, knowing it would destroy the partnership and saddle him with a business partner that he never wanted or chose. Angelina's side is that there was no enforceable agreement. She had every right to sell her share, and Brad's retaliating because she just won't stay silent about their personal issues. So why does this matter? Well, it's a really good example of what happens when romantic partners go into business together without airtight contracts, which you could conceivably see happening because when you're in a relationship, there's implicit trust, and that would just extend to a business agreement naturally in most people's minds, but is not necessarily a safe route. Verbal agreements between spouses or partners are notoriously hard to enforce, especially when the relationship falls apart. What could feel like a mutual understanding during the relationship quickly becomes he said, she said when lawyers get involved. There's also the fascinating layer where Brad's team is arguing that the sale wasn't just a business transaction, but an intentional act of sabotage. So they're trying to make claims of tortious interference, breach of fiduciary duty, potentially even fraud, depending on how those facts shake out. And we've got another layer, which is the international component, because this isn't just California family law. It's French property law, international corporate structures, cross-border business disputes. Getting a judge to untangle who owns what and who violated which agreement across multiple legal systems will take quite a long time and be messy. That's exactly why this case is still going. The bigger question here is whether Brad can actually unwind the sale, because Angelina already sold her half. The company already paid for it, and you're trying to get the court to reverse a completed transaction. That's incredibly difficult unless you truly can prove fraud or that the sale itself violated a clear enforceable contract, which you'll remember we said they had a verbal agreement. So my guess is that this would probably eventually settle with Brad buying out the Russian company, maybe at an inflated price just to regain control, or they carve out some kind of operational agreement where he runs the brand and they just own equity. But getting there is probably going to cost millions in legal fees. And honestly, at this point, the lawyers are probably the only ones winning. Okay, from French estates to streaming wars, let's talk about Drake versus the entire music industry. So this one's recent enough that people kind of remember it, but the legal details get lost in the noise. In late 2024, Drake's legal team filed petitions in New York and Texas claiming that Universal Music Group and Spotify artificially inflated streaming numbers for Kendrick Lamar's track Not Like Us, which if you somehow missed it, that was that brutal diss track aimed directly at Drake. Drake didn't file a lawsuit. He filed what is called a pre-action petition, which is basically a legal move where you're asking the court to force companies to preserve evidence and hand over documents before you officially sue. It's a way of saying, I think something shady happened and I need to see the receipts before I decide whether to go full on litigation mode. And the claims are pretty specific. Drake's team alleges that Universal and Spotify used bots, payola schemes, playlist manipulation to artificially boost streams for Kendrick's song. They're also claiming that Universal funneled money to radio stations to push the track and that Spotify's algorithm was manipulated to prioritize it. If true, that would be a massive, big deal and it wouldn't affect only Drake, but the entire streaming economy. Streaming numbers directly affect how much an artist gets paid. They affect chart positions, they determine who gets playlist placement, which affects future streams. The whole system is built on an assumption that these numbers reflect actual listener behavior. So if labels and platforms are gaming the system, then payouts are wrong, charts are meaningless, and similar artists who can't afford to pay for artificial boosts are getting screwed. Universal came back swinging, calling these allegations offensive and untrue. They said Not Like Us was successful because it's a good song and people genuinely wanted to hear it, not because of some conspiracy. It's tough for me to say because it was a really good song. Spotify hasn't commented publicly, but behind the scenes, they're likely freaking out because if Discovery moves forward, they'd have to turn over internal data about how their algorithm works, how playlist placements are decided, and whether labels pay for preferential treatment. That's the kind of information Spotify does not want becoming public. Now, here's the legal problem Drake faces. Proving artificial streaming manipulation is really hard. You would need internal communications showing coordination between Universal and Spotify. You would need forensic analysis of streaming patterns showing bot activity. You need whistleblowers or documentation proving payola. And even if you find that evidence, you then have to prove that it materially harmed Drake, which is tough when Drake is one of the biggest artists on the planet with billions of streams himself. But this matters more than just Drake's ego. If he gets Discovery and finds evidence of manipulation, He's opening the door for other artists to file similar claims. It could lead to class actions by celebrities. It could force streaming platforms to completely restructure how they handle playlisting and algorithmic recommendations. This case could fundamentally change how the music industry operates, or it could quietly settle with Universal paying Drake an undisclosed amount to make it go away and we never find out what actually happened. What's your bets? You know what mine is on. Personally, of course, I think it settles because Universal does not want their internal practices exposed, and Drake ultimately cares about money more than probably public validation or vindication. But if it doesn't settle and this goes to full discovery, then the music industry is about to get very uncomfortable. From streaming conspiracies to something much darker, let's talk about Marilyn Manson. In early 2021, Evan Rachel Wood publicly accused Marilyn Manson of abuse. She described years of psychological torture, sexual violence, and manipulation that started when she was 18 and he was 36. After she came forward, multiple other women did too. Ashley Walters, who was his personal assistant, Esme Bianco from Game of Thrones, Ashley Lindsay Morgan, all with similar stories of abuse, control, and violence. Manson, of course, denied everything. He called the allegations horrible distortions of reality. He sued Evan Rachel Woods for defamation, claiming she fabricated the abuse and conspired with other women to destroy his career. And then everything went quiet, the headlines stopped, and people moved on. But the lawsuit didn't. Evan Rachel Woods' legal team is fighting the defamation case, arguing that her statements were protected speech about her own lived experience. Esme Bianco's case is moving forward. Ashley Walters settled her case. The terms, of course, are undisclosed. What makes these cases legally complicated is the he said, she said nature combined with the passage of time. A lot of the alleged abuse happened years ago. So there's no police reports, no contemporaneous medical records. It's testimony, texts, witness accounts, and patterns of behavior. That doesn't mean the claims aren't true, but it means that they're incredibly hard to prove in court. Civil cases have a lower burden of proof than criminal cases. You only need to show that it's more likely than not that something happened, rather than proving like beyond a reasonable doubt. But even that standard is tough when you're dealing with private conduct from years ago. The discovery process in these cases is brutal. Both sides are demanding communications, therapy records, witness depositions. Manson's team is trying to paint these women as coordinated liars. The women's legal teams are trying to show a pattern of predatory behavior across multiple victims. Eventually, these cases will either settle or go to trial. If they settle, we'll probably never know the terms. If they go to trial, it'll be ugly, public, and re-traumatizing for everyone involved. But either way, Manson's career is functionally over. His record label has dropped him, tours got canceled, collaborations dried up. So even if he wins every lawsuit, the damage is done. And that's the part people don't talk about enough. Legal victory does not equal reputational recovery, especially in abuse cases. All right, let's end with something that might actually help normal people. The DOJ trying to break up Ticketmaster. Remember when Taylor Swift's Eras Tour tickets went on sale and Ticketmaster's website completely melted? Millions of fans crashed the system. Pre-sale codes didn't work. Tickets sold out in minutes. Resale prices hit 5 figures. Swifties lost their minds. Congress held hearings, and Taylor herself posted a rare statement saying the situation was excruciating and that she's been assured Ticketmaster could handle the demand. That public meltdown was the spark, but the DOJ's antitrust case against Ticketmaster and its parent company, Live Nation, has been building for years. Here's the core legal argument. Ticketmaster and Live Nation merged in 2010, and it now controls roughly 70% of the ticketing market for major venues. They own the ticketing platform, they promote the tours, and they control which artists play which venues. That vertical integration creates a monopoly where artists and venues have no real alternatives. If you're a musician and you want to play a major arena, you're probably going through Live Nation. And if you're going through Live Nation, you're using Ticketmaster. There's no competing platform with comparable reach. The DOJ's lawsuit filed in 2024 argues that this monopoly harms consumers through inflated fees, harms artists through worse contract terms, and harms competition because no one can enter the market and compete. Live Nation's defense is that they're big because they're good. They argue their fees are transparent, their technology is industry standard, and breaking them up would actually make the ticketing experience worse, not better. Courts are generally skeptical of antitrust cases because the legal standard is high. You have to prove the company has monopoly power and that they're abusing that power to harm consumers or competitors. Just being really, really big isn't enough. But the Taylor Swift debacle handed the DOJ a perfect real world example of harm. Millions of people experience firsthand how a system with no competition fails catastrophically when demand spikes. If the DOJ wins, Live Nation could be forced to divest Ticketmaster or break up its verticals so ticketing, promotion, and venue management are separate companies. That would fundamentally reshape the live entertainment industry. If they lose or if this settles with minor concessions, nothing changes. Personally, I think this case has legs. The Taylor Swift moment gave the DOJ political cover and public support. Judges pay attention when millions of voters are angry about something, but antitrust cases take years. We're talking discovery, expert witnesses, economic analysis, appeals. This won't resolve quickly. Still, it's worth watching because if the government actually breaks up a monopoly for once, it could signal a shift in how tech and entertainment conglomerates get regulated. And maybe, just maybe, buying concert tickets won't require a seven-figure salary and a computer science degree. So after walking through all of these cases that quietly keep moving while everyone else moves on, I want to talk about something related but a little closer to home. Because people always ask lawyers some version of the same question. What would you do? Or my favorite, what would you tell your sister, your best friend, your kid? And the thing is, the answer is almost never the dramatic thing that people expect. Lawyers do not live like people who believe that everything ends in court. We live like people who know that most problems never should. One of the biggest differences between lawyers and everyone else is that we're constantly running a cost-benefit analysis in our heads, even when we do not announce it out loud. For example, lawyers are much slower to escalate than people think. We do not jump straight to threats. We don't rush to file. We don't fire off emotional emails that feel good in the moment and age badly in discovery. When someone tells me, I just want to sue them, what I hear is, I'm angry and I want validation. That's human and makes sense, but it could be a terrible strategy. Most lawyers pause before taking any formal steps and ask a quieter question. What does winning actually look like here? Is it money, leverage, peace, or an apology that will never come? Because litigation is not a moral referee. It's a process, and the process does not care about fairness in the way that people think it does. So lawyers are far more careful with what they put in writing. We treat emails like they already belong to someone else because someday they might. When a lawyer writes an email, we assume a judge, jury, or an insurance adjuster could be reading this out of context 2 years from now. And that changes the tone. It changes wording. It changes what you do not say just as much as what you do. You'll almost never see a lawyer send a long emotional explanation in writing, not because we're cold, but because explanations can turn into admissions very quickly. Another thing lawyers do differently is how we enter agreements. We are allergic to rush signatures. Any deal that needs to be signed immediately without time to read it, without time to sit with it, without time to ask a question, sets off alarms. If someone says, this is standard, everyone signs it, most lawyers hear, no one has ever challenged this yet. Lawyers also care deeply about exit strategies, not because we expect everything to fail, but because we know that endings are where disputes live, so we want to know how something can end. Before we sign anything meaningful, we are quietly thinking about how someone gets out. What happens if someone wants to leave? What happens if money stops flowing? What happens if the relationship changes? Most non-lawyers sign based on how something begins, and lawyers will sign something based on how it could end. That mindset will show up in everyday life too. Lawyers do not overshare in conflicts. We do not vent to the other side. We vent to our friends, therapists, bosses, notes app. We do not vent to the person who could one day be adverse to us. There's a reason lawyers seem restrained during disputes. It's not because we don't feel things, it's because we have seen how feelings can become evidence. Another thing different is that lawyers don't confuse being right with being effective. They're not the same thing. You can be 100% correct and still lose time, money, sleep, momentum. You can also be technically wrong and still resolve something in a way that works for you. That's why lawyers settle things people swear should go to trial, not out of fear, but out of realism. Trials are expensive, they're unpredictable, they're emotionally consuming, and they put control in someone else's hands. Most lawyers would rather control the outcome than prove a point. There's also a reason lawyers tend to be obsessive about documentation. It's not because we love paperwork, it's because memory is unreliable and narratives shift. So we confirm conversations, follow up verbal agreements with short written summaries. We keep receipts not because we're petty, but because we know that clarity will prevent a conflict in the future. And when conflict does happen, lawyers are much less shocked by it. We do not take breaches personally in the same way. We see patterns, we recognize behavior, and we just adjust strategy. One of the biggest misconceptions about lawyers is that we're always looking for a fight. In reality, we're constantly looking for ways to avoid unnecessary ones. We don't threaten lightly. We do not bluff unless we're prepared to follow through. We don't say things we can't support. Obviously, generally, you're going to find your hothead all the time, but these are generally. When it comes to advising family and friends, the guidance is almost always boring. Document it, slow down, do not respond yet. Let me read that, sleep on it. Not glamorous, cinematic, but effective. That's also why lawyers tend to live more quietly during disputes. We're not posting about them or crowdsourcing opinions online, and we don't announce strategy before executing it. Because when something is public, you lose flexibility, which can be powerful. All of this ties it back to the cases we talked about earlier. The reasons those disputes are still alive years later is because decisions were made without thinking through the consequences at the beginning. Verbal agreements that felt fine at the time, partnerships entered without exit plans, power dynamics ignored until they mattered, systems trusted until they broke. Lawyers live the way we do because we have watched small choices turn into very large problems. So we pause, we'll write less, read more, ask uncomfortable questions early so we don't have to answer them later under oath. And maybe most importantly, we understand that not every wrong has a remedy that's worth pursuing. Sometimes the smartest legal moves are walking away with your time, your sanity, a lot of your money that you still have, and your dignity intact. That's how lawyers tend to live. So that's what's happening in the legal cases everyone forgot about. Brad and Angelina still fighting over wine. Drake thinks Spotify cheated for Kendrick. Marilyn Manson's lawsuits are quietly grinding forward. The government might actually break up Ticketmaster. None of these stories are giving us daily headlines, but they're all still alive in courtrooms, shaping industries, setting precedents, and reminding us that the legal system doesn't care about your attention span. Thanks for being here. If you want more of this kind of breakdown, share this episode with someone who loves a legal mess as much as you do. Find me on Instagram at JasmineWegESQ. Follow the podcast at Exhibit A-List Pod. Catch me on TikTok at Jazz the Lawyer. Next week, we're back with whatever chaos the legal system throws at us, because it always does. This has been Exhibit A-List. I'm Jasmine Weg. Stay smart, stay skeptical, and for the love of God, read your documents. See you next week.